that your name?
Yes.
That's where your signature should be as the Managing Director, yes?
Yes.
As MD, this is your health and safety manual, yes?
Yes.
Next page. You read this?
Yes.
When did you read it?
I can't remember off the top of my head.
In relation to the incident in February of last year, when do you recollect having read this document?
Probably when it was originally written and produced, which was 6 to 7 months before the incident.
So you did not refresh yourself from the contents of this document prior to each and every event you were involved in. Is that correct?
That's correct.
Did you ensure that any person who you were seeking to delegate responsibilities to refreshed their memory from this document before each and every event?
No, that's why I bring Lisa in.
When did you envisage reviewing this document from when it was first published?
When my safety consultant tells me it needs reviewing, I take their advice.
But people only give advice when they're asked for it. When did you have timetabled or scheduled a review of this document within your own practices as a managing director of the company?
I hadn't.
You didn't.
Yes, Mr. Campbell, are you wishing to address the jury at this point?
Is any real point? Repeating a good point doesn't make it a better point. Your Honour?
Well, that's all you want to say. Mr. Collett.
Thank you, Your Honour. Members of the jury, your minds are like parachutes. If they're not fully open, they're not working properly. You need to think about what you've heard. Have you heard something that shocked you to the core, that made you feel uncomfortable as the evidence unfolded? My learned friend said in opening that it's not about the criticism of the company. This is not some elf and safe day. This, he said, is important to protect the members of the public who were present. And how many members of the public were present on that fateful day in February? Not one. Not one member of the public. The only people on that site, whether employed by our company or with the security staff or misused. That's it. And who out of all of those people were doing their job properly? Was it misuse? Where does the blame stop? Was it good old Mr. Greaves? Make sure there's no unauthorised access by the public, checking passes, and ensuring that all vehicles have banksmen. Page 87. In the distance, I saw a buggy driving on the field without a banksman. I started walking towards it. I was about 50 feet away. 50 feet away? How's that being a security guard? I was looking after the bank that day the mobbers came round. I was down in the cost of coffee, but I was looking after it. Come on, members of the jury. What a fundamental failure. You've heard the evidence from my client, Mr. Woodford, who didn't have to speak to you, but he put himself in the witness box at the tender mercies of my learned friend to ask questions after questions. He was, quite properly, fiercely cross-examined. And what did he say, members of the jury? He said, I trusted these people. And that's the point, members of the jury. Who out of this do you think was trying to do the right thing? Was it MR Events Limited, who had put into practice a proper health and safety manual, proper risk assessments, proper site inductions, all of which have been okay. And indeed we heard, did we not, from Mr. Basharat, who couldn't say it was perfect. No, that was a step too far for him, but it was adequate. It ticked the boxes. Of course it did, it was perfectly proper. And yet, here we are. Poor old Mr. Boone. No one deserves that, and that's absolutely right. He was driven into by Mr. Roper. What was Mr. Roper doing? His job? Well, you've heard from him. I'm not entirely certain you know what his job is today. I certainly don't know how long he thinks he's going to keep it. But members of the jury, we don't have to prove anything. We learn the defendant's right. They bring this case. Look at the man there. Look at him, members of the jury. Sinned against or sinner? Trying to do the right thing or failing to be understood? Do you think his control of MR Events Limited was as poor as you've been led to believe? Or do you think this man did what he could? Put into place proper systems that two individuals that should have prevented the rogue Mr. Roper from rollicking around on the roving machinery. Where was the... Keep quiet. Where was the security to stop the transgression? Where was Miss Hughes, so formal and formidable in her right? Where was she to prevent Mr. Roper? And he read the induction. He'd seen it. He'd okayed it. He knew what he should do, but he didn't. Didn't follow procedure. He went off on a frolic of his own. A frolic. Is this the fault of this poor man? He does his best. He's a simple man at heart. Built himself up. Sophisticated, intelligent, debonair. There's just 3 words he can't even spell.
Stop talking about yourself, Gavin. The point is, are you convinced? Are you convinced? And how much can you, with your hand on your heavy heart, condemn that man to the rigours, to the otherwise unfortunate scenes of a conviction? Members of the jury, you are the final arbiters of fact in this court. When you go home tonight, to your home, your health and safety home, to your home, and that doubt creeps into your mind tonight, that is not the time to be pressing not guilty. It is now, members of the jury, to stand up and say, you have not proved this case, prosecution. That man deserves his chance. If God won't give him one, I will. Thank you, ladies and gentlemen.
Now, Mr. Collett, Mr. Campbell, before I direct the jury, can I just ask your assistance on a point of law? And it's this. Yeah, even from you, Mr. Collett. Question of vicarious liability. In relation to the actions of Mr. Roper, in particular, who is an employee of the company, what do you say, and how do you say I should direct the jury about the company's responsibility? Can I hear from you, Mr. Campbell, first?
Yes, Your Honour. It's easy to get confused by imputing issues concerning tort and vicarious liability into the criminal law. It's actually very simple, and it's outlined in the Act of Parliament itself. So if I can refer you to its kind, thankfully it's actually outlined in the Health and Safety Manual and the Policy, Section 2 of the Health and Safety at Work Act makes it quite clear that it is the company's responsibility, no one else's, to ensure health system of work and welfare for all its employees. The company is the one being prosecuted. He is the sole managing director of the company and therefore liable as a director in the name of the company. And if you'll forgive me, I had it when my learned friend was speaking. If I can turn to the act itself, you'll see. At page 53 or 54, the duties of the company in respect of employees, you'll remember that I cross-examined him on this matter. Section 2.1. The duty is only limited to the extent that once the jury is satisfied so that it's sure that there has been the injury, so we say because he was injured, therefore that's very simple, that's agreed fact. The only defence which the company could have is that they owed no duty, and we say, well, he's an employee, therefore he had the duty, or they did everything which was as reasonably practical to discharge their duty.
Well, I think the question I was asking you this, there are evident failings on the part of Mr. Roper as an employee of the company. Do you say on behalf of the prosecution that the company is liable for his failings?
For their acts or omissions of any employee, yes.
Yes, that's the question.
In the sense that, as was accepted in evidence by Mr. Woodford, that he could have put systems in place to ensure that Mr. Roper would not have fulfilled those failings.
Yes.
Yeah? You cannot stop anyone, as Malone Offence says, from going on a frolic of their own, providing you have as a company the checks and balances to, within reason, prevent those employees from going on a frolic of their own. There was no evidence put forward, and the absence of evidence is evidence of absence, that they have no systems in place to ensure that their employees do not go on a frolic of their own. So, for speaking sake, if Mr. Roper had driven his own motor vehicle into the middle of things, there is very little the company could have done to stop that. This, however, was a work vehicle. There was no proper system in place to ensure the adequacy, that the keys were only given to those who lawfully and properly should have been able to drive them. It was accepted in evidence by the managing director that there were ways he could have done it, checks and balances. He failed to take those reasonable steps, therefore we submit that there is evidence upon which the jury can convict. I hope that assists.
Mr. Collins.
Well, Your Honour, had it in one. If he's on a frolic of his own, there's not much the company can do. And that's the thing. If he's acting in the course of his employ, in other words, he's following the procedures set out, and he's following those procedures, and this occurs, may have problem.
So providing he's acting in the course of his employment, the company is responsible for his actions.
If he's acting in the course of what is set out, not if he is doing things that the company would not approve of. If he walked into his work, which my learning firm let me an opportunity of concluding my submissions, he can make it later in the court of appeal if we need it. The point is this, Your Honour, if he walks in with a bomb in his hands, just because he's at work doesn't mean the bomb is lawful. If we're beyond the wit of man to say that he would do that. The point is, if it goes beyond what he's permitted to do by the company, then he's acting as a frolic of his own. And what we say is clearly this man was on a frolic of his own. He was clearly not acting in accordance with the set procedures that have been put in place by himself and others, as you heard from Mr. Woodford and indeed from Mr. Roper and indeed from Ms. Hughes. They all have put the places in place. He didn't follow them. If he'd followed them, heaven forfend, we would not be here now, and poor old Mr. Boone would be unbanked.
Thank you very much indeed.
All I'll say, Your Honour, is that whatever he did so, and the company knew he was doing it. He'd been doing it for 5 years.
No, he didn't. And the evidence was he didn't know it.
Right.
Can't make it up. Come on.
Now, members of the jury, it's my task now to explain to you our respective responsibilities, my responsibility and your responsibility, and to tell you about the law, to remind you briefly of the evidence that you've heard, although you've heard it fairly briefly, and so I'm not going to go into great length, and then to hand over to you the task of making the decision. I think what we propose to do, and I know that this is a practical matter, I know there's a coffee break due at 3 o'clock, is to give you a chance to discuss amongst yourselves in our absence before you come back and vote, and then we will move on to sentencing if necessary, which it may well not be necessary. So let's start, members of the jury. First of all, your task and mine. My task is to tell you what the law is. And you take it from me that when I tell you what the law is, you have to accept that. Your task is to decide what the facts are, which parts of the evidence you believe, which parts you don't believe, what you think the facts are, having heard all the evidence. And you make that decision not by bringing any prejudices to bear from outside this court, but solely on the basis of the evidence that you've heard today in this court. Not by the clever points that either Mr. Campbell or Mr. Collett make, but by the evidence. It's the evidence that you've heard from the witness box and the statements that you've heard read that are the evidence upon which you will decide. Second thing for me to tell you, members of the jury, is the burden and standard of proof. Mr. Campbell touched on that at the start of the case, but what it means is this. The burden of proof is whose job is it to prove this case. And the prosecution bring the case. It's for the prosecution to prove the charge which is before you. You've heard it said that someone is innocent until proved guilty, and that is true in this case. Unless at the end of the day you find that the prosecution have proved the case, you'll find the defendant not guilty. The standard of proof, what that means is that unless you are sure that the defendant is guilty, you'll find the defendant not guilty. Just because you think the defendant may be guilty, or because you don't like the look of his face, doesn't mean that you will find him guilty. You must be sure on the evidence that the defendant is guilty. Now, the law. A couple of things I want to tell you very briefly. The charge that the company is charged with, would you like to have a look in the bundle at page 8? Because this is the indictment which sets out the charge which the company faces. And you'll see that it's a charge contrary to section 2.1 of the Health and Safety at Work Act, and that says it shall be the duty of every employer, that's the company, to ensure so far as is reasonably practicable the health, safety and welfare at work of all his employees. So members of the jury, so far as is reasonably practicable, the company has to take all reasonable steps. It's not a standard of absolute perfection. If the company has done all that's reasonable and falls short, the company is not guilty, but it's the duty of the company to ensure health and safety as far as that is reasonably practicable. And it's a matter for you, members of the jury, what you think is reasonably practicable. We then go on to the particulars of the offence. What it is alleged is how the company is said to have breached that duty. Is said to have breached the duty in three respects. Firstly, permitting Mr. Roper to drive a buggy without induction. Well, we know as a matter of fact that he was driving without any sight induction. Permitting him to drive a buggy without relevant training. We know as a matter of fact he was driving without relevant training. Permitting him to drive without inquiry as to whether he held an appropriate driving licence. Well, we know as a matter of fact that there was no inquiry as to whether he held an appropriate driving licence. And it's a matter for you to decide whether you are satisfied so that you are sure that in not making those inquiries and in not ensuring that Mr. Roper had that induction, not ensuring that he had relevant training, that the company fell short of the standard that's required by the Act. Can I just say one other thing? It relates to the discussion that I was having with counsel before I started this summing up. It's about the company's responsibility for the act of Mr. Roper. As far as the company is concerned, Mr. Roper is the fall guy. He's the chap who is responsible for all of this. It's nothing to do with the company. As a matter of law, a company is responsible for the actions of its employees. It's responsible for the actions unless, as you've heard counsel tell you, someone is going on a frolic of their own. What does that mean? That means basically that if somebody is carrying out acts within the course of their employment in the normal way of things, the company will be responsible for those actions. Somebody goes on a frolic of their own if, for example, it was suggested to you, they take their own car and drive into the middle of the site for no reason but just for the sheer hell of it. That's someone going on a frolic of their own. Somebody's going on a frolic of their own. I think Mr. Collett suggested if he brings a bomb onto the site, nobody expects them to do that. It's a matter for you, members of the jury, but as far as Mr. Roper was concerned, he was carrying out his responsibilities. He may not have been carrying them out very well. He may not have been following the instructions he's been given, but you may think that he was acting in the course of his employment. He was carrying out his responsibilities, although he was disobeying some of the rules. And if you think that he was acting in the course of his employment, although not carrying out, not following all the rules, then you will conclude, members of the jury, that the company is responsible for his actions. So that's the law. The evidence you've heard, I'm not going to spend a great deal of time on this, but you heard first of all from Mr. Basharat. He carried out an investigation. He is the one who has collated the evidence which has been put before you today. He was cross-examined uphill and down Dale by Mr. Collett perfectly properly about what he did and when. But you may wonder, members of the jury, how relevant any of that is. The evidence that we have before us today is here because of his actions. But does it matter whether he went north onto the field or south onto the field and what exactly he saw when? Matter for you, members of the jury, but that's a question you may want to ask yourselves. Miss Hugh, she was taken to her responsibilities under the company health and safety policy set out at page 60 in the bundle, paragraph 4 of the policy. And she accepted that these were her responsibilities. But ultimately the question for you is, is the company entitled to say, well, we've simply passed everything over to Miss Hugh, and we have no responsibility ourselves. We don't have to carry out any checks. We don't have to ask whether Mr. Roper has a driving license. We don't have to ask whether he's been trained. We don't have to ask whether he has induction. Clearly, Ms. Hugh had some responsibility for the matters set out on page 60. But does that mean that she's got the absolute responsibility and the sole responsibility for those matters? You then heard from Mr. Roper. It is quite clear that there were rules which are set out, I think, at page 32 in the induction procedure. It's quite clear that he did not follow those rules, particularly down the left-hand corner in relation to vehicles. And from what he told you, he didn't follow those rules because nobody stopped him. I've already asked the question and left you to think about whether that means that he was acting so far outside his sphere of employment that the company is not responsible for his actions. And then finally, you heard the evidence of Mr. Woodford. Well, Mr. Woodford's evidence, frankly, is it's all somebody else's fault. It's Mrs. Hughes' fault. It's Mr. Roper's fault. It's the security company's fault. I can cast my responsibility onto all these other people, and then it doesn't matter what I do. Do you think that's right, members of the jury? That is a matter for you. That is what lies at the heart of this case. And if you think that at the end of the day, if you are satisfied so that you are sure that the company, through Mr. Woodford, has failed by failing to ensure, in the respect set out on page 8, by allowing Mr. Roper to drive a buggy without sight induction, without training, without inquiry as to whether he had a driving licence, if you think that the company has failed in that way, then you will find the company guilty. If you think the company hasn't failed, or if you're not sure, then you'll find the company not guilty. Members of the jury, that's all that I propose to say. The time is now... can we have coffee early?
And indeed.
So why don't you go and get some coffee, have a discussion over coffee, bring back your coffee in here, if you're allowed to. I don't know whether you are allowed to. And at 3 o'clock we will start again, and we will hear your verdict.